Elzabar, ELC. Is there a Gary Young present? Gary Young?
Your Honor, as Mr. Elzabar walks out here to waive probable cause, I'd like to speak as to bond when the court's ready. Thank you, Judge. She's 28 years old. As you can see from the bond, she has no prior criminal history whatsoever, just one traffic offense. Gainfully employed at Interwork Packaging in Westchester, lives with his parents in Laughlin. Even in the light most favorable to the state, this is a situation where they're alleging that this was a situation with a former partner or relationship. This isn't really an aggravated robbery under any stretch, I wouldn't think. Burglary. I'd ask the court to consider an OR bond in this matter. As soon as he found out about this, we surrendered him in District 1 last night, and he's here to deal with this.
From the state,
Your Honor, state will be requesting no firearms and a high secured bond on this case, as well as a stay away, no contact from Gary Young. The allegation is that the defendant and the prosecuting witness were formerly in a relationship. The victim called 911 because of someone trying to kick in his door, and during the 911 call, when the defendant was able to gain entry into the victim's residence. The allegation is that there was a broken deadbolt and chain lock on the door. The victim was trying to hide in the bathroom. The defendant managed to get into the bathroom and then assaulted the prosecuting witness using a coat rack. I do not have any indication about whether or not the victim was injured or evaluated for injuries, but given the nature of the offense and the violence with which it occurred, state's going to request a high secured bond on this case.
as counsel stated, the defendant has no record. There's one prior failure to appear, looks like from a license or a traffic offense. Did we call for Gary Young?
I did, no response.
There's no bond preference listed. And this is from September of this year. And I'm sorry, you said the defendant turned himself in or was picked up?
We turned him in last night, District 1.
$50,000 anyway, plus juris if requested.
Grand jury date, January 20, 1/20.
Thank you.
Thank you.
Curry.
Morning, Judge. Judge, Adele Gray is on the felony case. I don't know. Is Adele back there? Or-
This is Dan Mike. It is. Dan's talking to her right now.
Okay.
She's coming loud.
You want to bring her? Curry, please.
Yeah. Ms. Curry.
On the felony and related misdemeanor, I'm submitting Edel Gray's designation. The felony is appropriate for drug court. Yes.
Very good attorney.
Good morning.
Yes, madam. This is smoking.
Does Ms. Curry have somewhere to go on electronic monitoring?
Your Honor, unfortunately, I don't think she does. I was just back there talking to her to kind of clarify where she would go. And I think she's truly without an address. She does have Edel Gray's business card right here, and she gave me a phone number so we can stay in contact with her. I think I know there's a lot of failures to appear. I think that has a lot more to do with basically kind of being right now, very disorganized and not really being a true flight risk. It is an F5 and she is going to be offered treatment, Your Honor.
Did you have anything?
Your Honor, these are KP's bonds from yesterday. I asked her about them. She told me that she thought court was today. She stopped by the officer, and the officer informed her that she did have these warrants out. As you can see from the new charges, based upon her contact with the officer, she was polite, cooperative. And you're familiar with the 2025 criminal history and dispositions.
When no detention hall, never. I never been in jail.
Andy Schengen's taking it back over, Judge.
Tom was the judge, White Tom. He volunteered at David Rest. So I did.
There are 5 prior failures to appear. I'm going to do supervised OR. There's prior 1 violent misdemeanor, 1 misdemeanor, no other charges as an adult or juvenile. This is a felony of the 5th degree, possession, and an M4 drug paraphernalia. This will go into drug court. It'll be a supervised OR.
Grand jury date January 22, 122.
Do all of these go together? Oh, no.
429 and 431 go together, not the others.
When was grand jury date?
122. Mariah Williams.
Ms. Williams?
Good morning.
Judge, we're here on a bond revocation. I believe you had heard Ms. Williams' case where this comes out of the BPO and felonious assault yesterday. You gave her a bond of $5,000 at 10% plus EMU. I'd ask you hold, just continue on her EMU here since she'll be held basically on that unless she's able to figure out EMU. She does have a good place to go with her mother that she was staying. She wants to get back to take care of her 2 autistic children, a 3-year-old and a 1-year-old. She did understand that this is a conflict for my office. Understood she is getting a new lawyer. We haven't gotten through that process quite yet. Rachel Myers is still attached. Ms. Gresham is on that currently.
Is this so this bond rev is related to yesterday's case?
Yes.
And it was revoked because of yesterday's
Yes.
case? Okay.
Defer.
I'm going to keep the same bond in this case. I won't revoke it because there was a new bond put on yesterday for that case. Do you know what the original bond was?
I do not judge.
I don't have the original judge's sheet.
Judge-
Do you know what the original bond was?
On mine, I think it was an alternate, something that
Yes.
OR.
Yeah.
EMU.
Yeah.
Yeah.
All right, and then I put a cash bond, yes, yeah. All right. All right, it'll be the same bond on this one.
Thank you.
All right, thank you.
Swearington.
Morning, Judge.
All right, we have put this on out of my room for a motion to modify today to comply with the Marcy's law.
Judge, and I appreciate that.
Has the state been able to reach the prosecuting, is the city closed? Has the city been able to reach the prosecuting witness?
Unfortunately, I have no information on that.
Do you want to recall
If we
it?
could, yes.
All right, we'll recall it. This was in my room January 2nd, and we put it on for today for it to be the 10 days for Marcy's law. All right, we'll recall it in the book.
And then, Your Honor, next on the early call is Castro.
We don't have the interpreter anyway,
So
so.
the interpreter anyways.
All right. Let's move on then. We'll recall it.
City DD docket.
Yes. All right, City DB.
GG's, Brandon Yang on behalf of the city, consultant Shante Dowdell. This is an order of protection requested. The Kia Williams. Kia Williams.
Wait, from Mr. Montgomery. He's right here.
Oh.
We have a Castro also.
Castro will be the interpreter.
Dowdell. Dowdell.
All right, Judge, good morning.
TPO.
He is executing the protection order at this moment in time. I did explain to him that he is to have no contact with her regardless of whether or not she reaches out or anything along those lines. We're gonna enter a not guilty plea, which should be heard with regards to that. He is 55 years old, Judge. He is employed. He works odd jobs here and there. He has executed the TPO. I'm showing 0 failures to appear, nothing pending while these allegations came about. Allegations are from the 22nd. He had contact with his mother who said Cincinnati had called him and said these warrants were outstanding. He turned himself in, adamantly denies the charges here, asking the court to go ahead and consider an OR bond. He is not a flight risk, considering the fact that he turned himself in, 0 failures to appear. They do not live together. This is not that kind of situation. So he does have a separate place to stay.
From the state.
From the state, we'd be asking for a monetary bond, based on the allegations that he punched the victim, with whom they did a child together with a closed fist, causing swelling above the right eye. It's also noted in the affidavit that one of the officers was present good distance then pleading.
There are 2 prior violent felonies, 2 felonies, 1 violent misdemeanor, 1 misdemeanor, 0 prior failures to appear in the past 5. There is not a bond preference, but in the complaint, the officer did note viewing swelling above the prosecuting witness's right eye.
I will note for your honor, because it did not make it into the affidavit, but Miss Williams is recently going through a situation where she had stabbed Shantae in the chest. So there is that situation right there. So what had happened on this particular evening was he went over, picked up his child because his child was being struck by Miss Williams, got her out of the house, and she had called the police following that situation, saying that she was struck. We do have witnesses that he went over there with because of the last time Miss Williams had attacked Shantae. So we do have those witnesses who are going to come in and say that there was no contact, everything was fine. It was based upon Miss Williams being upset and thinking that a potential charge could come down regarding the child. So I'm going to ask the court to take that into consideration with the SOR. The complaint is not, and I think it needs to be made clear that the observation of injury by the officer was not he observed the offense or that he observed the injury occurring, but that when he arrived, he noticed it as part of something that was visible to him. And I'm not sure that that was clear, so I want to make sure that that is noted. Hey, Brandon, did you call out for Miss Williams?
Yeah, I did.
On the DV, 10,000 anyway, plus jurors if requested. If there is jurors, the EMD will be open hours. On the assault, 2,500 anyway, plus jurors, same EMD open hours with the TPO.
Sign, sir.
Alexa Hill.
Defendant's mother.
You can't you're able to do it.
This is an order of protection requested. Hello, Juanetta Caetano.
Are you the prosecuting witness, ma'am?
Just for a minute. Let's try and get you.
All right, do you have your ID? If you could, if you just get your ID and show it to the deputy.
Miss Hill, correct?
Yes.
Yes.
Miss Hill? Make it their full attention, okay?
Yes, ma'am. What would you like to say?
It was a misunderstanding. She was trying to keep, I've been sick. I'm on a bunch of medication. She was trying to keep me over at the time. I'm a father, so she's my caregiver. So that night, it was just I was trying to go outside my apartment and tell the people next door to be quiet. Like, no, Mom, just go back to bed, because I'm on a lot of medicine. Like I said, if I get woke up, I don't even know sometimes I'm delirious and everything. I'm a father, so I don't have nobody at home. But that's my baby. It wasn't nothing intentional. I left, she's not no bad kid. Then it was me over-exerting something that made it more than what it was.
Are you concerned for your safety?
No, she takes care of me, and she lives with me.
Has anyone threatened or coerced you to be here today?
No,
Do you want a protection order?
no.
All right, thank you, ma'am. Did the state have anything?
Say what the code.
There's one felony, one misdemeanor, no bond preference listed, no failures to appear, no record or history of violence, with the prosecuting witness's statement, as well as the prosecuting witness at the time filled out the safety questionnaire and believed that they were safe and did not indicate any domestic violence risk factors. The bond will be OR. She'll be released shortly.
Shanika Jones.
Gotcha.
Are we ready with the interpreter?
Yeah.
I saw the interpreter.
He's here.
Ready to go. Okay.
Ruben's there.
All right, we'll do, after this case, we'll do Castro.
Thank you.
All right, thank you.
All right, not guilty on behalf of Ms. Jones, Your Honor.
All right. As to Tom,
As to bond, she is 35 years old. I'm only showing one failure to appear. I'm showing nothing of violence, no felonies, only a misdemeanor. I don't actually know what that is based upon the pretrial sheet I have. It didn't pop up in my history, so I apologize, but that's just what pretrial was showing me. This is a protection order situation. If you take a look a little bit closer into it, this appears to be a love triangle where she is going through a separation in a situation with her husband, and this is the other person who is involved in that. She was served with a protection order, adamantly denies any of these messages or anything along those lines, the phone calls and all that stuff that is being listed in the affidavit and complaint. She says never occurred. She got picked up in 585 yesterday because she was going to the protection order hearing. She came to court a week ago to try and get a continuance because we were having some childcare issues for the date. They had denied that continuance. She came in. This isn't a situation where she's running. This isn't a situation where she's ducking anything. She did not know about this warrant and all of that. She came into court. They said, hey, we believe you have a warrant. A couple hours later, they served the warrant on her. This isn't a situation where she ran, hearing that information. She has no problem staying away, having no contact with this person whatsoever. We'll note that the allegation is from December 19th. That is when the protection order was supposedly served personally on her. I did look at that notice of service based on docket that did occur in the late afternoon. She tells me that there was nothing posted upon this, nothing whatsoever. She's going to ask the court for the OR bond based upon this situation. She will not have any contact, and this has not been a continued contact situation.
did we call for Amber Clark? And what happened with the hearing yesterday?
I believe it was executed. The order has been.
Okay.
And that's based upon my conversation with her. The docket hasn't been updated from yesterday.
Okay.
But there is an ex parte in place.
Okay. From the state?
From the state, we would depose before that's bond.
Ms. Jones has one misdemeanor, one prior failure to appear. Based on the allegations and that there was no personal contact between the parties, this is social media allegations, will be a war, and she was in court yesterday. Ms. Jones, just for your knowledge, the protection order, no call, no text, no email, no social media, no contact through third parties. If anything, and I'm not saying that you have or did, I'm just letting you know for future. Anything that you do that encourages someone to reach out to the protected person can be held against you. So just this person does not exist in your life.
I
Okay?
have a question.
I don't ask it to your attorney.
Yes.
No.
So it's an OR bond, all right?
Thank you.
The TPO is already in place.
Thank you, Rose.
Okay, I don't know what that means. Thank you.
Joy.
Let's, do we call Joy? I want to do, yeah.
You ready? Room?
Yeah.
You need room?
Yep.
Pastor.
Monty, I don't have to let us off of the
Ms. Cox, for the record. Your Honor, we would be challenging probable cause.
All right. You said you are challenging probable cause?
Yes, Your Honor.
Can I have a reading?
Your Honor, allegations are that on or about September 1st of 2019, the defendant did knowingly touch the genitalia of LC, who's his younger sister. Victim was 7 years old at the time. Defendant was 15 years old. Allegations are that the defendant climbed on top of LC while she was lying on the floor and began squeezing her breasts and touching around her vagina over her clothes. As stated, the defendant was 15 and the prosecuting witness was 7 at the time. This report was made to the Springdale Police Department. Looks like the affidavit is sworn on December 16th of 2025.
Are you challenging probable cause because of the age?
Yes, Your Honor.
Let me see the parties.
So, who are you?
My name is Ashley.
Ashley? I'm Andy.
Hello.
Nice to meet you.
Nice to meet you. It's my boyfriend.
So, why are you here in court today? This is not the place to be.
I used to do criminal justice. So I used to work as a correctional officer. Sometimes you say stuff, but I'm one that work in the law right now.
Gotcha. So you're just here observing.
Taking
You do criminal justice?
Yeah.
I've been doing criminal justice for 36 years.
Really? You have your master's and your undergrad?
No. I got out of the Navy, came here and started working.
Oh, so what do you do?
I work for pretrial services, so we do all those. Everything the judges usually set up. We put all this together for the judge. So we interview everybody when they come in. So after that interview, you hear them talk about the ORS score. This is the ORS score. A good ORS score is a 0. The worst is a 9. So we hear them talk about the ORS score, but they get that in the interview. It kind of breaks down how that adds up. So then we do, actually this information is what the prosecutor has.
How to get this?
Yeah. That was kind of bare, but yeah. We could with some more stuff on it. I'll just look through it. Most of these are pretty bare.
So the higher the score is, it's more like, okay, you get it. The higher the score, it's like no bond, basically.
Right. Well,
What's the score
so
go through? How high is it going?
it goes up to 9. Yeah. So they're just live streaming you all morning.
Is my notes on the
One side.
I'm writing like a case, and I'm just writing like what I think it person be charged to get.
Right.
What she's actually doing. It's my first day. I'm sorry.
Yeah, when we get some more information. This is pretty bare. Usually people have come through here.
Wait a minute.
Not so much today. So this room changes all the time. So for the last few years, everything was every lockup was fentanyl related, and before that, it was all heroin. So it went from heroin to fentanyl. But went from crack cocaine to meth to heroin to fentanyl. So now we're getting back to crack. So it's kind of making a full circle because
Really?
I guess
That's on the streets again?
cocaine's more readily available now than the heroin. So we did have some xylazine in here. Not very much xylazine. It's that flesh-eating drug. That's some crazy shit. We didn't get much of that in here. That was more East Coast, West Coast stuff.
Really? See, when I was at Warren 11, we had one.
Quarters back in session.
Pills.
All right. I'll let the state make a record.
Your Honor, based on the allegations here, state and the jurisdictional question, state would ask for a one-day continuance. As far as the probable cause to hold, we'll leave that to your determination.
Your Honor, I'm sorry, I didn't mean to cut you off. We would be objecting to the continuance. We'd be asking that Your Honor find no probable cause and that Mr. Castro be released. Holding him a moment longer violates his constitutional rights at this point.
So this case was filed in the wrong court. The allegations at this point are undisputed, that at the time of the allegations, the defendant, who is currently 21, was 15. Juvenile court has jurisdiction. The case should have been filed in juvenile court. This court has no jurisdiction over juvenile cases. And so probable cause to hold is not demonstrated. I can't do anything in this case. So I understand the state's position, but I can't take jurisdiction of a case I legally don't have jurisdiction over.
Thank you, Your Honor.
Your Honor, just for my clarification, is the case dismissed at this point because you do not have jurisdiction?
Because usually we send them to grand juries.
I can't give it a grand jury because we don't have jurisdiction.
Yeah, so I don't.
I think Your Honor has authority if you don't have
To
jurisdiction to
dismiss.
dismiss it because you don't have jurisdiction, is my understanding.
Dismiss.
Okay.
Black jurisdiction. This is in jurisdiction. All right, are we ready on Castro? Yeah.
That was Castro.
That was Castro.
Oh, I'm sorry.
Judge, I believe we're ready on Swearington, although I don't know if you want to just finish the city DV docket for this.
Let's do Swearington real quick, because we were recalling that.
Swearingen.
I'll tell you in 35 seconds.
Were you able to get a hold of prosecuting?
Yes, Your Honor.
witnesses?
Prosecuting witness is here. If you want to step up here, sir.
Just look forward, pay attention to the judge.
Good morning, sir. If you would just speak into the box.
Yes, good morning, ma'am.
So Mr. Swearington is requesting that the bond of $10,000 plus EMD be reduced. Can you please tell me what your position is?
My position is, Your Honor, I think he'll serve a little bit more time than he's supposed to be. I have a forgiving heart, so when I get released today, it's good to be back with his family.
Are you concerned for your safety?
No, ma'am.
Do you want a stay away order or a juris monitor, which would prevent him from coming within 3 miles of your home?
No, ma'am.
All right, thank you, sir.
You're welcome.
Does the state have anything else?
Judge, I think a stay away, no contact order is appropriate.
I will modify to, there are 0 failures to appear. There is a criminal history. It looks like maybe before from 2000 Last conviction, it looks like it was 2006.
That's my understanding.
It'll be an OR bond. I will order stay away, no contact during the pendency of the case.
Thank you. Your
All
Honor.
right,
Judge, RIC for a pretrial, please.
all right,
Yes, a couple hours.
all right. We're on Joy now, Raina Joy.
There's an order of protection requested. Is it a Rosa Joy? Rosa Joy? Hamfield.
Are you Miss Joy? Do you have your ID? Deputy will take a look.
Rosa Marie.
Good morning, ma'am. If you would just speak into the box. Good morning. All right, I'll start with, I know this case is from, it looks like 2024. Do you want a protection order?
No, ma'am.
Are you concerned for your safety?
No, ma'am.
Has anyone threatened or coerced you to be here today?
No, ma'am.
All right, did you want to say anything else?
No, ma'am.
All right, thank you, ma'am.
Yes, ma'am.
Is there anything from the state? This is a 2024 case from January 13th of 24. This is the first time it is before the court. There is one misdemeanor in her adult record, 0 failures to appear, and no record of violence.
Judge, we would dismiss the court as a bond.
OR.
Time to call it.
Kimberly.
Kimberly?
There's an order of protection requested. It's a Joshua Bell.
Mr. Bell? Good morning, sir. If you would speak into the box, I'll start with, do you want a protection order?
Yes, Your Honor.
All right. And what would you like to say?
I would just like to say, I think that the defendant here, my girlfriend, needs some mental support, and that the presence of our child has not been a deterrent for the violent behavior before, and I'm afraid of the same thing occurring in the future.
Do you want, if there's a cash bond made, do you want a juris monitor, which puts a 3-mile radius around your home for her to stay away?
Yes.
When you leave here, you'll go over to 800 Broadway so that you can sign the paperwork to have that set up, okay? Thank you, sir.
Thank you, Your Honor.
Your Honor, not guilty on behalf of Ms. Kimberly here. She is 23 years old. I do have a good address over on Pepperidge. She was employed. She had a child. She gave up her career to go ahead and be a stay-at-home mom. She has obtained and achieved her associate's degree. I'm showing no history at all here. Adamantly denies the allegations, different versions of the facts. Moving forward, I'm going to ask the court to consider an OR with juris in this case based upon what he has indicated. She has signed and executed the protection order.
From the state?
From the state, we'd just like to note that the allegations are that the defendant only caused physical harm by scratching the victim in the face, and that she had a child. They both had a child with and was living together at the time.
This was not a warrant pickup, by the way. She did turn herself in.
There is no record at all as an adult or juvenile, no prior failures to appear. This is the first charge or anything at all and of violence. There was no allegations of weapons. The court finds that a jurist monitor is appropriate to secure the safety of the prosecuting witness, and that Ms. Kashu will return. It'll be OR plus jurist if requested, and the EMD will be open hours on the jurist
TPS time, sir.
with the TPO. Anderson,
Anderson?
Sorry.
Good morning. Waive probable cause.
We do, yes.
What is the charge?
Felonious assault F2.
All right, Esteban.
Your Honor, as to bonds, this isn't your standard felonious assault. I don't want to get too much in the facts. I'm sure the prosecutor will read a little bit more. But she has very little record. She only has 2 dismissed DVs, misdemeanor DVs from her record. The rest of it, I think she's got like 1 thing from juvenile, nothing else. And she was born in 1998, so she is an adult, has very limited record. She lives here in Cincinnati. I do have good contact information for her and another close friend of hers as well. She does have some health issues that she is on medication for, that she's concerned about making sure that she maintains that medication for her health. We are asking the court, I know it's an F2, but it's, it's a different one because this isn't your standard crime of violence necessarily. And I do think that there is issues with this case that are triable for sure. So I'd ask the court to take that into consideration, the fact that she doesn't have any failures to appear in the last 5 years. She has a very limited record and an ORS score of only 3. I'd ask the court to give her a OR with EMU. She indicates she can do EMU, that won't be an issue, but she wants to be out, make sure that she's taking her medication and fighting this from the outside. I did talk to her about whether or not anyone can post bond. She said money is extremely tight for her and her family, so no one's going to be able to help her with bond.
State will be requesting a stay away, no contact from Zion Isham, as well as STD testing as a part of this case. Allegations are that the defendant was engaged in sexual intercourse with another person, knowing that she was HIV positive and without disclosing her HIV positive status. The victim discovered this due to posts on Facebook, and it was later confirmed with medical records that officers subpoenaed with regards to Ms. Anderson.
As an adult, there is no record, no prior failures to appear. These allegations are from November of 2025. Does Ms. Anderson work?
She does not, Your Honor. She gets SSI.
OR plus EMD lockdown, except timeout for medical appointments only.
Would that also include court, Your Honor?
Yeah, medical and court.
Thank you.
Grand jury date 1/20, thank you.
Okay, I'll call you back.
1/20? Yes.
Thank you.
Barker, Brandon Barker.
I'm submitting Edel Gray's designation for Mr. Barker. This is another drug court case. We'll waive probable cause.
This is allegation that Mr. Barker had Percocet pills. How many pills does it say?
0.85 grams.
Huh?
As to bond.
Your Honor, he is 42 years old. He is a lifelong resident of the greater Cincinnati area. We have a good address for him. He reports employment through Best Staffing. This is a 5th-degree felony, and he is going to be offered treatment.
From the state.
We'll defer.
There's 1 felony, 1 violent misdemeanor, 5 misdemeanors, 5 prior failures to appear. This is use, not trafficking. Charge is F5, presumption of probation. There is no time preference listed. Because of the failures to appear, the court is doing EMD. I'll do open hours. Because of the 5 prior failures to appear. OR plus EMD open hours.
Grand jury date, January 21,
Thank you.
Baskins,
Hold on, check the shows. It's only probation violation.
Left boy.
That's
you.
I
If
have faith.
you're talking about a holder from Kenton County, that's, I have that from Bates. Are we on Bates?
I have dates. So we call, okay, dates.
Bates.
Judge, again, I am submitting Edel Gray's designation for Ms. Bates. This is another drug court case. Judge, we'll waive probable cause.
All right.
And, Judge, I don't think she can afford really any bond. However, I acknowledge that there is a Kenton County warrant. So I'd ask the court to set a very low bond.
Who's gonna be counseled?
It's going to be Edel Gray. This is another drug court case.
From the state?
state will defer.
Does your office have any objection to the change court coordinator based on the charges interviewing Ms. Bates for eligibility only?
I'd have to talk to her a little bit about that.
I'll just have the coordinator reach out to you. Because of the holder and the request for a nominal bond, it'll be 1,000 anyway, on each.
Judge, I did explain a little bit about change court, and that I think you are now the
Yes.
presiding judge, and Judge, there is no objection to that.
Okay, I will have Jessica reach out. Thank you.
Grand jury date, January 20, 1/20.
Don't explain it. The problem is you got a holder.
Judge, why don't you say?
And I'm sorry, were the misdemeanors OR?
What?
So why don't you call the next one so I have the order right?
Oh, it's black as next.
Okay, all right.
Judge, would you like a copy? Yes.
We'll waive probable cause.
All right.
Your Honor, as to bond, she does have a holder. Looks like it's for a theft that was capious. We're just asking for low bonds in this matter. It's possible these might end up going to drug court at a later date, but we'll address bond once we get that capious recalled.
From the state,
State will defer.
1,000 anyway on each.
Grand jury date, January 20, 1/20.
All right, thank you, Your Honor.
Thank you. Bogey,
Request for a temporary protection order. Is there a Maya Singleton? Maya Singleton? No response.
Judge will waive probable cause.
All right,
Ms. Cox for the record. I would ask to be heard as bond.
all right, Esteban.
Judge, obviously do note the parole holder. I would note this allegations from October of 2025. It was only filed in November of 2025 after she used his food stamps. And he confronted her about that issue. I do note the parole holder, so we would be asking for something nominal. He has executed that protection order.
From the state.
Your Honor, allegations, I don't have much by way of information other than the prosecuting witness went into the district and filed a desk report alleging that the defendant strangled her on October 28th of 2025 and was adamant about pressing charges with the execution of the protection order. State will defer as to bond.
Mr. Fogey has 4 violence felonies, 1 felony, no DV history, 1 prior failure to appear. The allegations are that Mr. Fogey choked Ms. Singleton and pushed her against the wall on October 28th, and that incident was reported November 24th. How did Mr. Fogey get turned in on these charges?
Marshal service.
There's a holder out. It'll be OR plus EMD plus jurist if requested. Because there's EMD on it, he'll still get credit for the days.
Thank you.
Grand jury date, January 20, 1/20.
Oh, hold on. Did he execute the TPO?
He did, Judge.
Honaker,
You just take your ID out for me.
Jackie Judge, if he comes on that, Mr. Honker, if you're. Jackie Judge, I got a driver's license for a Kyrie K. Hunter.
Your Honor, will waive probable cause and would just ask to be heard on bond.
Are you a prosecuting witness? Is there a CW in this case? No.
I think he may have information
Okay,
about
what
the
would you
case.
like to say, sir?
It was my weapon in the car that he didn't know it was up beside him. He was driving it. I forgot it in there after I got off work. And that's the reason why that he's in this position, because of me and my neglect of my own weapon.
Thank you, sir.
Your Honor, Mr. Honecker was borrowing Kyrie's car when he was pulled over by police. It's a window tint violation, and he gave consent to search the car, which I think demonstrates, any lack of knowledge of any potential weapons or any other issues within the car. I note that he has no FTAs within the past 5 years. I do have good contact information. He lives with his sister who owns her home. He has been working as in landscaping and is trying to find new employment as that has kind of slowed down with the season. He has strong community ties. We would ask for an OR bond.
From the state.
Request for no firearms, seeing as he's already under disability. Other than that, we'll defer.
So there are 4 prior violent felonies, 9 felonies, 1 violent misdemeanor, 4 misdemeanors, 0 prior failures to appear. There, it looks like Mr. Honaker was released November of 2024 for possession of a firearm. This date is not making that specific request, except for no firearms, which he legally cannot have. The officer deferred to the prosecution on the bond. Of note, in setting this bond lower than I typically would for this type of case, is our witness here stating that the weapon was his, the gun was not apparently out in the open. Mr. Honaker was stopped for attempted window violation, and per the statement of the facts, the officer asked for consent to search the vehicle, and he gave consent to search the vehicle, which if he knew it was a gun there, presumably he would not have said yes to searching the vehicle to find the gun. So the bond on this will be a supervised OR plus no firearms.
Grand jury date, January 22, 1/22.
Thank you, Your Honor.
Corinthia Lewis.
Ms. Lewis?
There's 2. Somewhere.
Way probable cause this morning, Your Honor.
1/22.
Ms. Lewis is eligible for diversion. She has no record as an adult or juvenile. This is an alleged theft from Macy's. Is there anything from the state?
Just stay away from Macy's.
Did you have
Just-
anything
just-
outside the OR box?
No, Judge, that's it.
OR plus stay away from, you waive probable cause.
I did waive probable cause, yes.
All right, so Ms. Lewis, you can't go to any Macy's store, all right? All right, thank you. Stay away from Macy's.
Grand jury date, January 22, 1/22.
Thanks very much.
O'Brien, Stephen O'Brien. Cleric Constance O'Brien, she's present. Request for an order of protection.
Good morning, ma'am. The deputy will look at it in a minute.
Good morning, ma'am. Oops, sorry, there's 2.
Is the victim the same at all? Yes.
Just trying to be curious.
Go right in the middle, make sure turning the whole thing, and you can face the judge. All right? We will take care of the rest.
Good morning, ma'am. What would you like to say?
I would like to say that because of this incident the night it happened, I towed my car, trying to get away from him. And I have been unable to stay in my house before he turned himself in when the police were looking for him, because I was scared to death that he was gonna come back. And if it were up to me, he wouldn't get any bail, he'd be locked in jail.
So based on what you said, I'm assuming you want a protection order,
Yes,
correct?
ma'am, I do.
And you would want a juris, which if he was able to make the cash bond, that there would be a radius around your home.
Yes.
And based on what you said, also, you're requesting the cash bond?
He don't have any cash, but he's gonna post it for me.
Thank you, ma'am.
Thank you.
Ask the bond.
Your Honor, we would waive probable cause. As to bond, Mr. O'Brien has had no contact with her or the residents. He has obviously a completely different version of events as to what occurred. But in any event, he does not wish contact. He has executed the protection order. He did turn himself in to Delhi Police Department yesterday. He did have a job. He had been working at a local restaurant. He is a life resident with strong community ties. There's no felony record here. He has no funds, no money to post for bond. He does have, he can stay with a friend who does live here locally. I have good contact information for all of that. So we would ask for an OR bond.
From the state.
Based on the prosecuting witness being here and her explanation of what she's looking for from the court, state's gonna echo that. State's gonna request a high secured bond, no firearms as a condition, and juris if requested. The allegations are that the defendant struck the prosecuting witness, who is his mother, in the face, then pushed her against a wall and put his hands around her neck, constricting her airway. She's obviously still extremely fearful for her own safety. The state has concerns for her safety if the defendant is released. So we're gonna ask for a high secured bond.
Jace, can you look up something? This 22 DV is 22 CRB 5151. Can you tell me if that was an import and one?
What was the number on
22 CRB 5151.
Okay, what do you want now?
Was this the conviction in M4 or M1?
Doesn't look like it's screened in CMS, so I'm not sure. See the judge sheet if it has anything. It doesn't have anything scanned in for the plea.
All right.
It just says they went through probation.
Okay, thank you. All right, there are 4 violent misdemeanors, 6 misdemeanors, 1 prior failure to appear. In 25, there was a DV amended to an attempt. In 22, there was a TPO violation amended to a disorderly conduct. In 22, there was a domestic violence conviction. Not sure if it was a 1 or a 4. Because this is a misdemeanor, I'm assuming it's a 4, or it would have been charged as a felony. In 2012, there was a DV amended to an attempt by the same prosecuting witness as is here today. Based on the history, what has been said by the prosecuting witness today. And just for the record, there's no bond preference indicated. On the strangulation, it will be $25,000 secured plus EMD plus juris. On the DV, $15,000 secured plus EMD plus juris. On the assault, $15,000 secured plus EMD plus juris.
Grand jury date 1/20, January 20. Owens, Leonard Owens.
Right to the current, and get the one.
Good morning, Your Honor.
Waive probable cause?
Yes, Your Honor.
All right, ask the bond.
Your Honor, as to bond, we are asking for a low bond. Mr. Owens is 38 years old. He is a life resident of Cincinnati. He has been employed at Spotlight for the past 2 years where he works full-time. He lives with his grandmother and 10-year-old who he has custody of. He does take that child to school and provide, of course, all the daily care for that child. So he is anxious to be released for that. He has some college. He's got a year of business management. Unfortunately, he does not have money to post for bond, so we are asking for a low bond. I would also note he has a 2 ORS score and 0 FTAs within the past 5 years.
From the state?
Your Honor, this was part of an undercover operation carried out for the Cincinnati police. Made entrance into, make sure it's not far. Officers obtained a search warrant, went to the defendant's residence, and during a search of the residence, officers recovered 20.27 grams of crack cocaine and 405.51 grams of fentanyl inside the residence. Obviously, those are very high volumes. There was also evidence that the defendant was trafficking various items of drug paraphernalia found inside the residence. State's going to ask for a high secured bond, no firearms as a condition. Yeah, nothing further.
I would note that the address he resides at with his grandmother and child is a different address than what is listed in the citation where the search was. I'm also unclear that there are any lab reports confirming whether or not there are controlled substances and what the official weights would be if there are.
Information in the arrest report indicates that prior to the execution of the search warrant, there was a controlled purchase from the defendant of items that were believed to be cocaine and fentanyl. Those items were sent to the Hamilton County Crime Lab for testing and came back positive for those drugs, which led to the execution of the search warrant. As for the drugs that were collected during the search, I don't see anything about a lab being returned yet.
There is 1 prior violent felony, 10 prior felonies, 6 of which are trafficking convictions, 5 misdemeanors. There are no failures to appear in the past 5 years. These charges are based on the amounts that were listed in the complaint, felonies of the 1st and 2nd degree. On the F2, trafficking in cocaine, 20.27 grams, 50,000 secured plus E&D. On the trafficking in fentanyl, 405 grams, which is an MDO charge. 75,000 secured plus E&D. Same on each count of the possessions, 50 and 75.
Grand jury report dates January 21, 20.
January,
20.
thank you.
Parrish,
Your Honor, on the felony and the related misdemeanor, I'm sorry, Del Gray's designation.
Submitting my own designation to Ms. Parrish.
Right in the middle, and you're clear attorney. So you have to do all-
Waive probable cause, Your Honor.
Is that a good phone number?
You waive probable cause?
Yes, Judge.
All right, I set a bond on this last night. I'm not inclined to change it. It's OR EMD because there's only 2 misdemeanors, but the EMD was because there's 5 prior failures to appear. It looks like there is a good address for EMD. So is there anything else that the parties want to address?
no, you're
Not at this point.
So OR EMD, she should be in line for it since I set this last night. And then on the resisting arrest, I don't change other judges' bonds up or down, so Judge Yates had put an OR on it, so that will remain the same on that case. On the other, he put a OR on the glittering, and then on the M4 drug paraphernalia OR. All right?
Thank you.
Grand jury dates 1/20, January 20. Joshua Payne, Sir Kalen Hicks, request for temporary protection order.
Let's get the full attention, make sure you face the judge, okay? We'll take care of the rest. Yes, sir.
Very probable cause this one, Your Honor.
Right, as to bond.
Mr. Bond, Your Honor. Mr. Payne is willing to sign the temporary protection order, if I can find the right page.
Yes, sir, what's your relation to the case?
I'm his father.
Okay.
Caitlin is the one that called me last night. Said she didn't think she had to be here because she had told the police that she didn't want to press charges at the time. But I'm just here.
Okay, thank you, sir.
So along with that information, Judge, Mr. Payne, he is willing to execute the temporary protection order while this is pending. Your Honor, I mean, he denies the allegations. He doesn't dispute that they had a verbal argument. I think he made a statement of something about push, but not choking. Your Honor, Mr. Payne has no record. There's not some history or pattern of this with this couple or with his history in general. He's a graduate of Winton Woods, Judge, lifelong resident of the area. He actually was, he had been temporarily staying at his sister's because they're deciding whether or not they are going to get divorced. But, and this was he was at his sister's house when this confrontation occurred. So he has no problem staying away and abiding by the protection order. We know it's a serious allegation because of the nature